Thank you very much. Thank you very much for Jacek, the invitation. Actually, I'm almost an accidental participant because I was originally just a traveler across Krakow on this day, on the way to Warsaw. Therefore, but when I heard about the event, I thought I was happy to attend and listen. But then Jacek encouraged me to get involved perhaps more actively because for the reason I travel to Warsaw and anyway to discuss some of the aspects of this controversy surrounding political changes, legal changes, economic changes in Hungary and EU response from various institutions. And in this context, because as we know very well that one of the major political source of disagreement between the Hungarian government and the EU institutions was practically seen that not even the adoption but rather the entry into force of the new Hungarian constitution was the trigger of these really intensive and actually multiple forms of criticism actually or multiple fronts these criticisms. So it seemed that somehow all these questions around the Hungarian democratic institutional system and the operation of the Hungarian constitution and the rationale and the purpose and the consequences of the new constitutional rules and those rules which must be adopted as a consequence of the new constitution seemed the political ground for all these accusations, claims about practically the constraints, limitations, or even the distortion of Hungarian constitutional system. So we are not, of course, go into details of all the aspects of the new constitution. Myself, actually, I'm more interested in international law and in the EU law, but certainly because it's also public. We are involved and interested in public affairs. Therefore, the constitutional changes, particularly living in Hungary, cannot leave anybody interested in public affairs or politics really unaffected. So, as not a constitutional expert, I'm rather looking at the problem or the situation from the perspective of how European institutions and why and on what issues they engaged Hungary and really brought Hungary under some real severe criticism, and even now they formally launched a procedure which is generally used for all sorts of breaches of EU law as a consequence of Hungarian national legislation or even the failure to adopt some rules in Hungary. But this time it seemed that this procedure was used particularly to pinpoint some of those very sensitive issues which could be directly identified with the entire constitutional system and also the operation and the nature of Hungarian political system. Even if these criticisms seem very technical and focused on certain aspects of the Hungarian rules, of those so-called cardinal laws adopted in consequence of the new constitution, of the fundamental law, but these criticisms were related not only just very technical or precise aspects of these laws challenged by the Commission, by the European Commission, but rather they told that this is indicative of the entire trend and the direction of Hungarian constitutional changes. So it seemed that from the point of view of the European institutions, we can distinguish two approaches related to the Hungarian constitutional situation now. One is really and practically very openly political by nature. This was the European Parliament, the main front of political criticism in the European Parliament. The other major institutional actor in the process, the European Commission, according to its own nature and its own functions conferred by the treaties of the European Union, it must also kind of present its own approach and observations in a more neutral less political, more technical, legal perspective. That's why we could, the criticism directed at the Hungarian constitution and the changes were some of them calling the whole political system, the democratic nature, and the constitutional principles of the new fundamental law into question. That was the European Parliament, and the European Commission was more choosing those elements of the new rules which could be identified as conflicting with EU law. So we knew that the motivation, and even every time, even when the European Commission makes comments, even last time, when actually it was 1.5 weeks ago, Hungarian Prime Minister met the President of the European Commission, even if they discussed the questions which were actually presented to the Hungarian government, but of course the comment which the President of the Commission made was more political. So we can always see the political context, but because they must discuss constitutional questions and legal questions, there is some point in the process where these criticisms or these objections or doubts about the Hungarian constitutional changes must be really identified more precisely. So that's what the Commission had to do. They cannot go on forever with these political questions, only just saying that there are political concerns about the nature and the changes in Hungary. But there was some questions how then they could really find those elements in the transformation, the constitutional transformation, which can be grabbed as really clearly, at least seemingly. We will see later how much it is really in confrontation, in conflict with EU law. A bit more, this is just a general context at why this whole debate between EU institutions and Hungary and the Hungarian government should be also explored from perspective of constitutional law, because after all, now it seems that when the questions are presented and identified more precisely, these are legal questions, seemingly. Because after all, political debates can go on, and it's, of course, we know it can be very complicated, and it's a process which often has its own kind of self-motivating or self-propelling dynamics within the European Parliament, but the Commission has to be, by definition, more precise. And this is what the Hungarian government wanted and waited actually for, and expected, told that, okay, name the problems. Where are exactly the problems? And then actually it was also very, very illustrative and very instructive to learn where exactly these points stand out, where Hungarian rules can be really read and interpreted as in violation of some norms somewhere, either in the treaties or in the secondary sources of EU law. First of all, the situation with the Hungarian constitutional changes and the European institution, the debate, clearly demonstrates that nowadays, when we say that the primary of EU law is really enshrined in the Treaty of the European Union, it really means that even the constitutional rules and those rules which stand at the level of the constitutional norms can be challenged on the basis of EU law. If somebody had any questions whether EU law is only about the norms related to the single European market, and it's very technical, loads of, as we know, that there's so many questions and so sophisticated that really now with tens of thousands of pages. But there are clearly questions when we can find the constitutional element where the EU law affects the national legal system. And the Hungarian situation clearly tells us that even if there are very kind of sensitively protected divisions between the competences of the European Union and the member states, this division of competences can be again questioned, and then it seems on a solid basis, as the Commission presents its own argument, it can question whether these issues belong to the Hungarian national competences, or when they can identify where these questions overlap with EU law, then they can say yes, even if it's constitutional norm, but nevertheless EU law must take precedence. So it is a very kind of clear example when it shows that national constitutional norms are simply no justification that we say that it falls within the national competence of the country and it is determined by the constitution, therefore it should be beyond the reach of the European institutions. Clearly, the Hungarian case illustrates that very easily when it comes to technical aspects, these legal questions, then even the Commission can kind of intrude into areas which are regulated by national constitutions. And also in the Treaty on the European Union, it is identified that the national administrative arrangements and structures and traditions should be respected. This is something which everybody must accept, that all member states have different constitutional traditions, even if there are a lot of kind of expected common norms, fundamental law rights, fundamental freedoms, but then there's still something which is clearly beyond the reach of the EU law. But then this is also somehow in contrast with the reality of this expanding body of EU law. When the Commission identified those problematic parts, actually I think this was only the first round, probably later we can expect further results of their examinations and analysis when other rules adopted, even if not formally written in the Constitution, but adopted at the same level, 2/3 majority, as called the cardinal rules. And in this question, mainly, these are the areas where the Hungarian Constitution will be developed further, where the real implementation, for the implementation of the Constitution is necessary. So therefore, I believe that even in the future we can also expect more. But the approach will be the same, that the European institutions will examine these questions, and even if they have many problems, even perhaps of the principles or some of the declared values and some of the policy choices which is really written in the Hungarian Constitution, but this is something which they formally cannot challenge. This can be challenged in the European Parliament. So it's kind of division of labor. In the European Parliament, you can challenge those political opponents of the ideological stance or the policy choices of the Hungarian government. They can challenge it in the European Parliament. But when it comes to these more precise forms of confrontation, it could come when you can identify whether the age, the pensionable age of the judges, which is now reduced to a level of the general level, of course, we have exceptions, so that's the European Commission can use. Let's say that when you say that you don't do anything else, you just make something really a rule you want to turn into a general norm, and then when it is in the interpretation of the European Commission, it questions the potentially, at least, the independence of the judiciary. It says it can question the effect, but the real question what they use is one of these universal arguments that discrimination under EU law is not possible. So immediately you come to one of those well-rehearsed, well-practiced arguments which you can find in EU law, that discrimination in any form is not agreeable. And then after all, you question the independence of judiciary, which is just a presumption, but when you can find a sharp argument which can be used for the same purpose, then even constitutional rules can be challenged on the basis of the norms written in the sources of EU law, also kind of stressed in the judgment of the European Court of Justice as well. And another aspect which I want to mention without wasting too much of your precious time, perhaps we can discuss more elements and come back to some other issues in discussion. But I wanted to also mention that the question of the fundamental values, which is also at the same time, it seems now, that at least at the level of the political discourse in the European Parliament, this is something which is used as a threat form of, as an instrument of pressure. That if the majority, the political body in the European Parliament and among the member states, means the representatives of the member states in the Council, could find that Hungary somehow threatens fundamental values, and the fundamental values, to a great extent actually, it's of course the same, but it's written in the Hungarian constitution. But somehow you can see that even if it's written in the Hungarian constitution, they might, some kind of examination or analysis or interpretation could lead to the conclusion that even if the constitution protects these fundamental values, but somehow the implementation of the constitution points into a different direction, and the political position of the necessary majority can be actually assembled, and this could really be a ground for an action which is unprecedented so far, but it is a possibility written in the EU treaty, the so-called Article 7 procedure, when you say that first step you warn and openly declare that a country poses actually a threat. In the treaty it says clear risk, which is very difficult to define, so it's clearly it's just more or less it's a political question to decide when you can detect certain risk, and clear risk directly leading perhaps to the serious violation of fundamental values. It is highly political, but it seems that these fundamental values, even if they overlap, could be a source for really such a kind of a criticism which could really discredit the entire constitutional changes and constitutional transformation in a country. So this is some of this this fundamental values of EU law, and on the basis of these of the risk, or even this, of course, the worst case when you say that they can establish that serious and persistent breaches of EU values has been really taken place in a country, then the heads of state or government can declare that it happened and now sanctions will come. But this would be, of course, a very devastating option, and I think it would really be a very divisive option, because to question the fundamental values and the respect for fundamental values in a country on the basis of its own practice, and the whole debate based on the argument that new constitution, which has the same clear commitment to the values which are supposedly in threat, this is very contradictory, even not only in political terms, but even in I think, even in terms of analytical or theoretical sense, that when we look at this question, unless you clearly give some very convincing examples, I think this sounds like a very strange exercise. It's a very kind of weird attempt to establish that already within the European Union there are some countries where, when their constitution could launch a process which could lead to this dramatic situation. I think it is now what we can really observe. Probably all these institutional participants, mainly the Parliament and the European Commission, now they really try to extend and practice their kind of their maximum stretch of their power and competence. That they really want to, perhaps if the situation requires and the conditions are favorable, they can really show the maximum strength of their institutional capacity. So it is like a demonstrative action, but certainly, you know, some of those changes in the constitution which can be identified in this legal analysis presented by the Commission, if those are well funded, Hungary must react, and certainly even norms at the level of the constitution must be brought in line with the EU law, because it's also actually simply, it's an obligation of the member state. But beyond these few examples,